This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're speaking about why some people bring to courts of appeal their own errors and refuse to accept the fact that they have made an error and understand that their agent binds them if they are the principal, and that rejection of UIM coverage by an agent is always valid. Brandon Lawrence appealed the trial court's order finding Progressive Northern Insurance Company made a valid, meaningful offer of underinsured motorist coverage to his agent, Ashley Outlaw. In Progressive Northern versus Brandon Lawrence, the Court of Appeals of South Carolina on April 17, 2024, explained the law of agency and its relationship to insurance. From 2008 to 2013, Lawrence and Outlaw lived together in the same house with their son. They never married. They split the household expenses, but Outlaw paid the bills and took care of insurance needs. On August 19, 2009, Outlaw purchased an insurance policy from Progressive to cover Lawrence's motorcycle. However, Lawrence did not discuss obtaining UIM coverage with Outlaw, nor did he read the policy, did not have any involvement in obtaining the policy, and did not have any contact with Progressive. The application for the insurance was mailed to Lawrence and Outlaw. It listed Outlaw as married and as an insured, and Lawrence as married and as Outlaw's spouse. On September 5, 2009, Outlaw signed the application form and rejected Progressive's offer of UIM underinsured motorist coverage. Outlaw paid the premium for the policy, and Lawrence reimbursed her. In May of 2013, Lawrence was involved in a motorcycle accident. On August 12, 2016, Progressive filed a declaratory judgment action and sought a determination that UIM coverage was offered to Lawrence through his agent Outlaw, and that Lawrence was bound by Outlaw's rejection of UIM coverage. The trial court found Lawrence was bound by Outlaw's rejection of UIM coverage because Lawrence appointed Outlaw as his agent to obtain the policy. Lawrence testified in his deposition and at trial that he knew Outlaw was getting insurance, that he asked her to do so, and that she had his permission to do so. The Court of Appeals noted that it is well settled that the relationship of agency between a husband and wife is governed by the same rules which apply to other agencies, and no presumption arises from the mere fact of the marital relationship that one spouse is acting as agent for the other, even if they're not spouses and are just living together. An agency relationship may be, and frequently is, implied or inferred from the words and conduct of the parties and the circumstances of the particular case. Therefore, the Court of Appeals held that an agency relationship existed between Lawrence and Outlaw, and that Outlaw's rejection of UIM coverage bound Lawrence. Lawrence stated he assumed Outlaw would purchase UIM coverage, but he did not discuss such an optional coverage with her, did not read the policy, did not check to see if the policy contained UIM coverage, or have any contact with Progressive himself. Lawrence gave Outlaw the authority to obtain the insurance policy, and he is bound by Outlaw's rejection of UIM coverage. To hold otherwise would allow Lawrence to benefit from Outlaw's procurement of the policy, but not be bound by her rejection of the UIM coverage, and not pay a premium for the risk he thought they were taking. Automobile insurance carriers must, by statute, offer at the option of the insured underinsured motorist coverage up to the limits of the insured's liability coverage. Progressive's application included the words underinsured motorist coverage and several paragraphs that explained what such coverage entailed. Additionally, the information about UIM coverage offered by Progressive was not found in a separate form. The UIM information and rejection form was included within the main action that Outlaw received and signed. Progressive made a meaningful offer of UIM coverage to Lawrence's agent, Outlaw, and Progressive's offer of UIM coverage was made through a form it sent to Lawrence by mail. Progressive's offer of UIM coverage specifically outlined the limits and intelligibly advised Outlaw, who acted as Lawrence's agent, of the UIM coverage availability. Outlaw had experience purchasing insurance in the past by regularly handling the insurance needs of the household and bought exactly what she wanted to buy in accordance with the normal types of insurance purchased for the household. In my opinion, it's sad that Lawrence was injured by an underinsured motorist and could not recover from his motorcycle policy because his wife rejected Progressive's offer of UIM coverage as his agent for the motorcycle policy and other policies for their family. The case ignored the fact that she lied on the application about a material fact, claiming that Outlaw and Lawrence were married when they were not. If that was a fact material to the decision of Progressive to issue the insurance, it could have declared the policy void for a material misrepresentation of fact or rescind the policy. Not necessary, of course, because there was no UIM coverage. But because Mr. Lawrence didn't want to abide by the terms of the contract, and because he refused to accept that he had erred, he took the matter by litigation to trial, lost at trial, and took it up on an appeal where he had absolutely no right to cover. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. If you subscribe, you will receive notice of every blog posting, usually 5 or 6 a week, and you'll have access to the more than 4,750 blog postings. You can also subscribe to these videos. They're free at rumble.com or at youtube.com. And if you're interested in more detail about insurance, insurance claims, insurance fraud, and insurance law, please consider for a very small fee subscribing to my Substack publication. Thank you for your attention.